So welcome. After the break, we had covered in the last session up to section 135. So up to section 135, we have covered. Now let us go to section 136. So we are trying to have a brief overview of the provisions contained in Insolvency Act. In the previous section, we have covered up to section 135, and now let us go to section 136 onwards. Section 137 talks of transition for states of Malaya. So proceedings that were pending against the under the old bankruptcy order when this act commenced are treated as if they were started under this act. So old orders, notices, and appointments made under the old ordinance remain valid. Section 138 says regarding Sabha and Sarawak district officers, every person exercising district officer powers in Sabha or Sarawak is automatically an assistant director of insolvency for their district, and this ensures insolvency administration reaches rural areas where there are no dedicated DGI offices. Section 139 says that ongoing Sarawak or Sabha ordinance cases, so states under the old Sarawak and Sabha bankruptcy ordinances are completed under those old laws, not this act. So why this matter? The act has been in force since 1967 and had to handle transition from colonial era laws. So these actions ensure continuity. Now let us see the practical guides, the key processes, flow charts, and tips for beginners. So bankruptcy process, step by step. First of all, debt arises and it remains unpaid. Creditor serves the notice of bankruptcy. Act of bankruptcy is committed. If no revert within 7 days, creditor files bankruptcy petition. There is a hearing by the High Court and bankruptcy order is made. DGI takes over the assets of the bankrupt, creditor meetings and proof, and then assets sold and dividends paid and discharged after a period of 3 to 5 years. This is the entire process in brief. Voluntary arrangement, how it works. Step 1, debtor appoints a registered nominee. It applies to the court for an interim order, 90 days protection. Debtor prepares statement of affairs with nominee. Nominee summons all creditors to a meeting. Creditors vote on the proposal by way of a special resolution. And if approved, nominee reports to court and voluntary arrangement becomes binding. The nominee supervises implementation of the repayment plan, and on completion, debtor is free from those debts. Now, ways to get discharged from bankruptcy. So there is a court or DGI certificate route. Court discharge is as per section 33. So you can apply to High Court at any time, and if court considers the conduct and cooperation and creditor payments, so it can discharge the bankrupt, and court may impose conditions, for example, pay sum to creditors. So this is the most flexible but uncertain outcome. DGI certificate is granted as per section 33A, and DGI issues certificate without court involvement, but the bankrupt must have cooperated and paid DGI's determined amount. So creditors can object within 21 days of the DGI certificate. Automatic discharge. This is most common. So automatic discharge is handled by section 33C. So after 3 years from submitting statement of affairs, what are the conditions? You must have paid DGI's determined sum and cooperated fully. DGI gives notice 6 months before discharge, and creditors can object and court may suspend up to 2 more years. So this is the best route for most bankrupts. But you have to remember that discharge means clean slate for government debts, fines, and fraud debts. But guarantors are not released by your discharge. So discharge is not considered to be a clean slate for government debts or fines or fraud debts, which you are still required to pay despite the discharge order. And guarantors are not released by your discharge. So what are your rights as a creditor before bankruptcy? You have to serve a bankruptcy notice on a defaulting debtor, and you can file a bankruptcy petition if debt is 1 lakh ringgits or more and an act of bankruptcy was committed within the last 6 months. After the bankruptcy order, you have to file proof of debt to participate in dividend distributions. You have to attend and vote at creditors' meetings. You have to apply to join the consultative committee, and you can inspect the documents available with DGIs on payment of fees. Any appeal against any DGI decision can be made to the High Court by virtue of Section 86, and the creditor can object to a bankruptcy discharge within 21 days of notice. Fraud, if any, report any suspected fraud by the bankrupt to the DGI, and DGI has police-like investigative powers to pursue fraud. Your rights as a bankrupt. So you have the right to receive notice of all creditors' meetings and proceedings. You can contest the bankruptcy petition in court. You have to submit a statement of affairs. You can be examined publicly, but you can also explain your circumstances. You can apply for voluntary arrangement before bankruptcy. You can apply for composition or scheme of arrangement after bankruptcy. You have to apply for travel permission from DGI. You have to apply for permission to run a business from DGI. You can appeal any court or DGI decision, and you shall be discharged automatically after 3 years if certain criteria are met, and you are entitled for any surplus which remains after all creditors are paid in full. Now, common myths about bankruptcy in Malaysia. What are the common myths? I can be bankrupted for any unpaid debt. Fact is, you need at least 1 lakh ringgits of debt before a creditor can petition. Right? Another myth is, once bankrupt, I will never get out. Fact is, automatic discharge after 3 to 5 years under Section 33C. Another myth is, all my debts disappear on discharge. The fact is that government debts incurred by way of fraud and fines, they still survive the discharge which you are required to pay despite the discharge order. The real facts. There are certain more myths. My house and car will be taken immediately. The fact is that basic necessities, tools of trade, and items in your name on trust are protected. Another myth is my guarantors are also protected. The fact is that your discharge does not release guarantors from liability. Another myth is that I can give my property to my family to protect it. The fact is transfers made within 2 to 5 years before bankruptcy can be reversed by DGI. So key figure thresholds and time limits at a glance. 1 lakh ringgits is the minimum debt for a creditor to file a bankruptcy petition. Section 5. 1,000 ringgits is the minimum amount for an execution to constitute an act of bankruptcy. 7 days is the time to respond to a bankruptcy notice served in Malaysia. The act of bankruptcy must have been occurred within 6 months of the petition. Duration of interim order in a voluntary arrangement is 90 days. 3 years is the period after which automatic discharge can occur under Section 33C. 5 years is the maximum look-back period for avoiding voluntary settlements. 12 months is the period for priority tax debts and employee wages in debt distribution. And 15,000 ringgits is the fine for acting as nominee without registration. And 2 years is the maximum jail term for most fraudulent bankrupt offences. Special protections. Who is a social guarantor? Section 2. So a person who guarantees a loan for non-profit purposes in any of these categories. A guarantee for an education loan, scholarship or research grant. A guarantee for a hire purchase of a vehicle for personal or non-business use. A guarantee for a housing loan for personal dwelling only. Why special social guarantors get special treatment? A parent who guarantees their child's education loan should not be treated the same as a commercial lender. The law recognizes that social guarantees are given out of family duty and not for profit. So what protections apply? Social guarantors are treated more leniently in bankruptcy proceedings. The 1 lakh ringgit threshold and other rules are applied fairly to their specific circumstances. So what is the advice? Always understand your obligations before signing a guarantee. Even a social guarantee is legally binding. Section 84A, DGI's special investigative powers. So what powers does the DGI have? The DGI has all the powers of a commissioner of police for the purpose of this act and fraud offences under the Penal Code. Investigation officers. DGI can appoint investigation officers who have the powers of a police officer. What this means practically, DGI can investigate you like the police, DGI can arrest suspects, DGI can require any creditor to assist in estate administration. What are the penal code offenses relevant to bankruptcy? Section 421, which covers the dishonest or fraudulent removal of property. Section 422, which includes dishonestly preventing distribution of property. Section 423, which covers dishonest execution of deed of transfer. And Section 424, which covers dishonest or fraudulent removal or concealment of property. Now, Schedule C. How to prove your debt as a creditor. What does proving a debt means? A creditor must formally submit a proof of debt, a claim form to the DGI to participate in dividends. What are the key rules from Schedule C? A proof must state the amount and nature of the debt with supporting documents. Secured creditors must state the value of their security. They can only claim the balance. Unliquidated and contingent debts must be estimated and proved. A creditor must prove their debt before a dividend is declared to receive that dividend. What is important for secured creditor? If a secured creditor votes at a meeting for their full debt, they are deemed to have surrendered their security. The DGI can require the creditor to give up the security for the estimated value plus 20%. Practical tip is file your proof of debt early to maximize your dividend entitlement. Schedule A, rules for creditors meetings. Notice requirement. First meeting, at least 7 days notice is required, and for subsequent meetings, at least 3 days notice is required. What is the quorum? 3 creditors or all creditors, if there are 3 or fewer, must be present or represented. If quorum is not met within 30 minutes, meeting stands adjourned to the same day next week or 7 to 21 days later. If adjourned meeting also lacks quorum, the chairman proceeds anyway. Voting rights. Only creditors who have filed proof of debt can vote, cannot vote on unliquidated or contingent debts. Proxy voting is allowed. Proxy form in prescribed form deposited with DGI before the meeting. No self-interest voting. A proxy holder cannot vote for any resolution that benefits themselves from the estate unless they are also a creditor voting purpose. Now let us do a quick recap, putting it all together. Things every beginner must know about this act. Bankruptcy in Malaysia requires at least 1 lakh ringgits in debt. Small debts cannot trigger formal bankruptcy. Voluntary arrangement is your first line of defense before bankruptcy. Try to use it early. An interim order gives you 90 days of breathing room. You respond to all bankruptcy notices immediately. After a bankruptcy order, all your assets, with limited exceptions, stand transferred to the DGI. There is automatic discharge after 3 years is now available. So bankruptcy is not a life sentence. Hiding assets, falsifying records, or lying to the DGI is a crime which can land you up to 2 years in jail. Government debts, fraud debts, and criminal fines are not cleared even despite the discharge order. Your guarantors remain liable even after you are discharged. And a bankruptcy order does not stop a secured creditor from enforcing their security. The DGI has police-like investigative powers, so full cooperation is essential. Essential glossary of bankruptcy terms, this you can go through. This is an FAQ, which you can go through on your own. I will share these things with you. This is the timeline, voluntary arrangement versus full bankruptcy. What are the key differences? Composition versus scheme of arrangement, how bankruptcy affects your family, and what are the practical tips to avoid bankruptcy. So I hope you enjoyed this presentation. I have made a chart on this criminal offenses also, a quick reference table, which is for your reference, right? So this is all for today's deliberation on Insolvency Act in Malaysia. I hope you enjoyed this. In case you feel this video worth it, you can share it with your co-professionals, and you can subscribe to our channel also for receiving regular updates. Thank you so much for watching this.